So it's my pleasure to introduce the first speaker, Mr. Andrew Lockhart, who is the National Manager of Refugee and Protection Unit at Immigration New Zealand. So thank you very much.
Thank you, and thank the organisers for the opportunity to participate in this 800th anniversary of the Magna Carta. And tonight, as the Chair said, looks at the area of immigration and refugees and its relationship to the Magna Carta. The Magna Carta itself was a short-lived document signed by a king under duress from the barons, aggrieved over a number of matters they wanted addressed, some of which were specific grievances and others were more fundamental. The 1215 Magna Carta lasted only a short period before it was annulled by Pope Philip, but the ideas continued to evolve and strongly influenced the Constitution and arrangements in the United Kingdom. So what is the influence of the Magna Carta on immigration and refugees, and why, and what has been the impact on both New Zealand's approach and the international context in which we operate? I'm going to look at the systems that support the refugee determination process and how the principles of the Magna Carta actually contribute to that. The important influence of the Magna Carta, which is well covered in literature, is that in signing the document, King John subjected himself to the law, and whilst this particular commitment was short-lived, but for King John, the principle resurfaced in subsequent documents. And that over time, those established the principles that came to be known as the rule of law, which eventually was incorporated, as I said, into the English Constitution and eventually exported out to the Commonwealth. The rule of law at its heart is the principle that no one is above the law and that governmental authority is to be legitimately exercised in accordance with adopted laws, with the administration of them undertaken with due process and fairness so as to avoid arbitrary decisions. For those of us that work in the immigration field, that is a critical part of our training and development right from the beginning, especially around the due process and fairness. Underpinning that, those rules of law are the principles of parliamentary sovereignty, which we've come to know, the separation of powers between the executive, the legislator and the judiciary, and the judicial independence and impartialities, which supports the premise that no one is above the law and all are subject to it. So how over time has the refugee system in New Zealand paid heed to those principles evolved from the Magna Carta? The Convention on the Status of Refugees came into effect internationally in 1954, but New Zealand's only signed the Convention in 1960, and it wasn't given effect in legislation, but in the 70s the government established the Interdepartmental Committee to consider refugee cases, which were at that time very few in number. The committee consisted of officials from the Ministry of Foreign Affairs and the Department of Labour, who was at that stage responsible for immigration. The recommendations of the committee were referred to the Minister of Immigration and the Minister of Foreign Affairs. Final decisions made by the Minister, and there was no established mechanism for an appeal. These arrangements continued right through up to the 1980s, and the number of claims at that stage started to rise. Then in 1983, the system was challenged, robustly challenged, by the arrival in New Zealand of Jagpal Singh Benipal. And many of you will know the decision. He arrived with no passport and was detained under Section 14 of the Immigration Act 1964. This made him subject to immediate removal, but while he was being held pending removal, he made a claim for refugee status. That was considered by the committee without Benipal being present or represented. His claim to status was declined. However, intervention by Amnesty International and others secured him a second opportunity to have his claim decided, and he was this time interviewed at the prison. The second claim was again declined by ministers, and Mr. Benipal then sought a writ of habeas corpus, which was successful, and he was released from prison on bail.
At the same time, he sought a judicial review of the minister's decision. It's that review that the judge held the committee had not acted fairly, in that it did not disclose the substance of prejudicial material against Benny Powell. The court also found that some committee members had approached his hearing with closed minds, and there was a very likelihood that the decision had predetermined. The case was appealed to the Court of Appeal, but by that stage, Mr. Benny Powell had residence under the regularisation program. This case was instrumental in spurring significant change to the refugee determination system, which were incorporated into the Immigration Act in 1987. The changes provided for the initial claim for refugee status to be determined by refugee status officers, with appeals heard by the Refugee Status Appeal Authority, an independent body with members appointed for a fixed term by the Governor-General. The 87 Act did not codify the Refugee Convention, but it did provide a reference to the way cases were to be determined and remove ministers from the refugee decision-making. The Secretariat supporting the Refugee Status Appeals Authority consisted of staff from Immigration New Zealand as part of the Department of Labour, and the establishment at the same time of the Removals Appeal Authority was responsible for considering humanitarian appeals for those liable for removal, provided an additional avenue for those who may not have met the requirements to be recognised as a refugee, but nevertheless had exceptional humanitarian circumstances, which could be taken into account. In addition to these independent appeals bodies, the 1987 Act provided for an appeal on point of law to the High Court and left open the door for judicial review, although it restricted the time that the review could be taken following an adverse decision or finding. It was about that time that the Convention Against Torture came into force, but this instrument was not brought within the jurisdiction of the Refugee Status Appeals Authority, nor the Refugee Status Branch or Status Officers. It was left to be considered by immigration officers with support from the Legal Division. This included assessments undertaken prior to removal. These arrangements lasted until 2010, when the Immigration Act 2009 came into force. The 2009 Act brought together 4 previous appeal authorities, including the Appeal Review Tribunal, and established the Immigration and Protection Tribunals within the Ministry of Justice. In addition, the Convention Against Torture and the International Covenant on Civil and Political Rights were brought into the broader immigration decision-making process, providing for what is now called refugee protection officers who were responsible for those determinations. It provided for an appeal to the IPT, and appeals on the point of law and the right of judicial review remained. So how has the Magna Carta influenced the system and judicial arrangements over the history of the refugee status determination in New Zealand? And to what extent has its influence strengthened protection? Clearly, the Benny Powell case demonstrates that investing all the decision-making with the Crown did not provide the checks and balances that you might expect to find in a system established to provide protection. However, the writ of habeas corpus, so clearly associated with the Magna Carta, did provide a safeguard to support protection. The subsequent court findings provided a very clear steer towards the useful next stage in the refugee status determination in this country. The changes in the 1987 Act did provide due process, even though the Convention itself was not codified in the Act. The changes establishing the appeal process and placing the initial decision-making in the hands of specialists more closely aligned to the principle of the Magna Carta relating to due process and the rule of law. There was, however, still criticism that the appeal authority was within and supported by Immigration New Zealand, who was also responsible for those initial determinations. The Immigration Act in 2009 moved the appeals, as I said earlier, to the Immigration and Protection Tribunal under the Ministry of Justice. That Act strengthened protection by including the 2 complementary protection issues within those arrangements. These new arrangements follow the principle originating from the Magna Carta, but I am sure that any future changes will continue to be influenced by the enduring principles of due process and the rule of law. I do want to conclude by taking a quick look more broadly at international protection provided by those states who are not signatories to the Convention. The 1951 Convention relating to the status of refugees and its protocols have been called the Magna Carta of international refugee law, but only just over 140 countries or states are signatories, and yet 80% of the world's 20 million refugees are hosted in developing countries, most of which are not signatories. How is that protection and the rights of those ensured? The Universal Declaration of Human Rights is often called the International Magna Carta and provides civil and political rights internationally, which no doubt influence the way in which states respond, as does customary international law, which recognises the role of states as international citizens and the rights and commitments that come with that. It's not clear whether these ideals stemming from the Magna Carta have influenced the responses by states, but what is evident is that countries neighbouring conflicts, and even those further away, have responded humanely to the situations by providing temporary protection and a commitment to non-refoulement, which so importantly underpins protection. However, like the barons of 1215 who lost the rights they had secured in a matter of days, these rights accorded to those fleeing conflict remain fragile, especially given the number of protracted crises and the highest number of refugees since the Second World War. The Magna Carta, the significance of which in its time was unrealised, has evolved to mean so much more than a list of demands. The principle of the rule of law, and in particular due process that evolved from the Magna Carta, underpin and provided under the Refugee Convention in New Zealand, and at least influence the international approach to protection. Thank you.
Thank you very much, Andrew. Just to assure you, we will be having question time at the end of the three speakers.